All rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in the case of John R. France versus Industrial Commission of Arizona, Gila County and the Arizona County's Insurance Pool. Case number 1CA-IC18-0047. Council, I remind you that this argument is being audio and video recorded, so I'd remind you to please state your names as you begin your arguments. Each of you will have 20 minutes. Each side will have 20 minutes to present your comments and arguments. Appellant's counsel, if you watch the clock and retain as much time as you deem necessary for rebuttal. And also, please keep in mind that we have read the briefs and we have conferenced this matter, so we're quite familiar with the basic facts and procedure of the case. With that, counsel for appellant, you may proceed.
May it please the court. My name is Matt Fendon. I represent the petitioner John France. I would like to reserve 5 minutes of rebuttal time, and I will watch the clock. Your Honors, we respectfully request that the ICA's decision be set aside. I'm going to take us back quickly to Father's Day of 2017. You've seen the video, you've read the briefs. Essentially what happened is the suspect burst out the door with a shotgun, headed right towards Sergeant France, and France had to reposition himself so his partner was out of harm's way. He ended up with a 12-gauge shotgun 3 to 4 feet from his face and upper section. Sergeant France was faced with a life or death situation. Kill or be killed. Him or me.
Counsel, to this point, that's all uncontested, correct?
Correct. Sergeant France thought he was going to die. Once the barrel was raised towards his face, he had to fire once, twice, 3 times, 4 times, and 5 times until the suspect passed. Sergeant France watched a human being at point-blank range die in front of his eyes. As a board-certified workers' comp attorney that's handled thousands of cases, if this isn't unusual, unexpected, or extraordinary, I don't know what is. The entire argument of the respondents is a red herring. They're focusing on the tactical training of Sergeant France. They're not focusing on the actual event. They can't focus on the actual event in their argument because they know it's unusual and extraordinary and unexpected. Again, they don't talk about the real issue. The real issue that's before Your Honors is having to kill somebody at point-blank range to salvage your own life and watch the person die in front of your eyes. Every officer is trained to draw a gun. We know that. But there is a small percentage that ever ends up in a circumstance where they have to take a human life at point-blank range. That happened with Sergeant France.
Counsel, are we looking at whether the event was unexpected, unusual, or extraordinary, or whether the stress was? Or are we looking at both?
We're looking at both, Your Honor.
How do we get that from the statute to look at both? Well, let's go back a little bit. What did the ALJ look at? Did the ALJ look at both? And so do we do the same?
The ALJ bought their argument, the red herring argument that I mentioned. The ALJ bought that the tactical training is enough to make it not unusual, unexpected, or extraordinary. But that's not what the case law says, and that's not what the legislature intended. The legislature and the case law all focuses on the events themselves, not the tactical training.
Counsel, when I was reading through this, it seemed to me like everybody wanted to focus on a split-second circumstance, which was when your client had to decide, do I pull the trigger? It struck me that from the time they went there, they knew there was history, right? They'd been advised that there was this circumstance that they may get calls on, right?
To an extent. And
just take me to that extent. Go with me for a minute on that.
okay.
They got there. and I've seen the video, and they effectively separated for tactical reasons, probably very good reasons. But then when the individual came out of the door, all of a sudden he's standing point blank between your client and his partner, correct?
Correct.
So there had to be decisions made at that point about, do I risk a shotgun blast to the face, or do I take a shot and maybe hit my partner? I mean, wasn't that part of the consideration?
So, first of all, they didn't know that they were going to be rushed by a 12-gauge shotgun that day.
Or they found out quick, didn't they?
They sure did. They sure did. And as you saw in the video, Your Honor, that shotgun was at Sergeant France almost the entire time. So Sergeant France had to reposition himself, as you saw, so he didn't get in Deputy LeBont's, so he didn't basically endanger Deputy LeBont's life.
So your client had to delay, as I perceive it, as I watched the video, it appeared that he had to delay protecting himself so he could make sure he didn't kill his partner.
Absolutely.
Part of the consideration?
Absolutely. You got it. That's part of the whole circumstance there. So it was Sergeant France that had his life put on the line. It was Sergeant France that had the gun in his face the entire time, almost the entire time. So yeah, that's all part of the equation.
Is that part of the tactical training?
It may be.
Or is that going with what you find yourself having to deal with?
Tactical training only goes so far. It's basically
But how far?
It's like an advanced video game. That's how they testified to it in the ALJ's proceedings. That doesn't change the circumstances here, that this is an actual event. You can't train for this type situation. And even if you did, it doesn't take away from the fact that it's so rare and so unusual that it almost never happens. The defense's own witnesses, we got 135 years of combined experience that went in front of the ALJ. Not one of them had ever been in a gunfight. And that's what it comes down to. This is so rare, this is so unusual, this is so extraordinary that it almost never happens, especially when you're looking at a rural county like Gila County.
So can we limit the event to just the pulling of the trigger? Or is it what leads up to the pulling of the trigger that sets the mind for what follows?
What the event is, Your Honor, is pulling the trigger and having to watch a human being die at point-blank range. That's the event.
But that's, counsel, that has to happen. I mean, maybe not in Gila County, but in Maricopa County, that happens more often than we'd like to know. I can't quote you a statistic, but I would assume you'd agree it happens a lot more in Maricopa County than it does in Gila County. Are you suggesting that in each of those situations where an officer has to shoot and kill an individual, that officer is entitled to workers' compensation because as a matter of law, essentially, those are extraordinary events?
Your Honor, I think
In
from a
each
point...
instance, yeah.
I'm sorry.
I was just wondering, in each instance.
Yeah. So first of all, Sergeant France works in Gila County. He doesn't work in Maricopa County, so that's apples to oranges.
Although we have the fireman's case that I think compared it to all DPS officers. I mean, that was the comment made by the Supreme Court, that there was comparison to all highway patrol officers.
The Fireman's Fund case, if I recall correctly, was before the statute was codified.
True.
So basically, it's our contention that even in Maricopa County, if you have to take someone's life at point-blank range, it's unusual, unexpected, and extraordinary. You can argue the tactical training all you want, but that doesn't change the fact that it's not a usual occurrence. Your Honors, if you uphold the ALJ, this is going to have broad consequences. We could potentially wipe out PTSD claims for all first responders in the state of Arizona. The way that
is there any reported decision, well, I'll ask this, unreported or reported decision that has upheld an award to a first responder for PTSD or similar?
Well, you can go back to Brock.
Vision.
Now, again, that's before the statute was codified. That's 1971. You go back to Brock, and that was the only acute case that I could find, Your Honors, where it wasn't a gradual type buildup of stress. That was an acute case. That was the case where
Refresh my memory.
the city worker ran over a pedestrian.
Not a first responder, but
but
a precipitating event or traumatic event.
Yeah, a traumatic or an acute type event. That's the only published case I could find, and again, that was before the statute, but that claim was found compensable. And then when you read Larson, which is mentioned in that case, all of Larson's recommendations are that acute type cases like this should automatically be accepted. So the fact that this claim was ever denied in the first place is baffling to me. Most of the cases that you've read are all gradual type cases, like the Sloss case, which involved the highway patrolman and things like that. So this is an acute type case that hasn't been published, to my recollection, and since Brock, which was in 71.
Counsel, should we be interpreting the statutory limitations in light of the Constitution, our Constitution, which generally says, I think, that there should be compensation for work-related injuries?
Yeah, so the Constitution says that accidents arising out of and in the course and scope of employment that are caused by necessary risk should all be covered. That's what Article 18, Section 8 says. So the way the ALJ ruled in this case violates the Constitution, essentially, because you're creating a higher standard. 23-1043-01B creates a higher standard above the basic guarantees of the Constitution.
Now, it seems like there are sound policies behind the statute with regard to mental injuries, but nonetheless, shouldn't the overarching constitutional directive just inform our understanding of how the statute ought to work?
So,
in other words, if it seems perfectly sensible to perhaps exclude mental injuries where the injury seems disproportionate to the stressor, and then so the statute makes sense in that regard. It's creating either a distinction or a hierarchy, but
sure.
Nonetheless, when we're thinking about what that means, unusual, extraordinary, I would think that would be in light of the constitutional directive to compensate for work-related injuries.
Well, believe it or not, in reviewing all these cases, it didn't appear that the fact that it requires more of a necessary risk has ever been completely flushed out by the courts as whether it's constitutional or not. The statute, there was a good intent behind the statute, and obviously that was back in 1980. Mental stress claims have evolved. We see PTSD in our soldiers that come back from the military now. PTSD is kind of at the forefront these days. So the statute serves a good purpose, and I concede what you're saying, Judge Thompson.
I guess I'm saying it's one thing to say the statute's unconstitutional. It's another thing to say, well, we should read the statute in light of the Constitution.
Yeah.
How could we interpret this statute? How could we interpret this statute so that it's sort of serves both purposes? That it complies with the mandate of the Constitution, obviously, but yet fulfills the statutory intent to sort of weed out certain types of mental injury claims.
So there are multiple ways. First of all, Finley said that all stress cases should be treated the same way, right? So under Finley, a police officer's stress shouldn't be treated differently from a barista at a Starbucks stress. That Finley basically said all stress claims should be treated the same way. Furthermore, if you are going to treat officers the same, it needs to be apples to apples. Gila County officers to Gila County officers. So the statute serves a good purpose, but it still isn't perfect by any means. And I think the reason why the statute was enacted back in 1980, things have changed since then. So And I think that you still have the problem where it violates the constitutional guarantee that any injury by necessary risk is covered. So I don't think, to be honest with you, Your Honors, that you even have to get to that part of the argument. I think that this clearly fits in the unusual. I shouldn't say I think. I know this clearly fits in the unusual, unexpected, and extraordinary circumstance. So you don't even need to get to the constitutional argument if you don't choose to do that. This is not...
Deference, if any, do we owe to the ALJ on that question?
I don't believe you owe any deference to her. This is a legal question subject to de novo review, essentially. So...
I have a question here. I'm intrigued that you wanted to compare Pinal County to Pinal County or Maricopa County to Maricopa County. Why isn't that an officer put into that situation that is trying to protect his partner at the same time, has a shotgun in his face? Why isn't that the same, whether it's in Maricopa County or Pinal County or Pima County or anywhere else?
I think what we're going to go to, Justice Jones, is the amount that this happens. The amount of times that this happens in Maricopa County is going to be extremely different from the amount of times that this happens in...
Getting shot dead is pretty much getting shot dead, isn't it?
I agree.
Whether you're in central Arizona or southeastern Arizona. So why do we draw a geographical distinction where the end result is really what we're trying to address?
I don't believe you even need to draw a geographical distinction. I was just throwing that out there. Essentially, I think I told you this earlier. I think if this happened in Maricopa County, this would be unusual, unexpected, and extraordinary. I am at 4:50 now, so I am going to sit down. Thank you.
Good morning. I'm Lori Vopel, counsel for Gila County and the Arizona County's insurance pool. The stress or the test under the statute requires the court to look at not just the specific event, but whether the stress of the employment is a substantial contributing cause of the mental illness or condition when compared with the stress that other similarly situated employees with those same duties are applied to, or are exposed to. The court, from the very beginning, where it first limited the initial case of Brock, from Shope all the way through, and especially in Sloss, even before the statute was passed, the court made clear that you must look at whether it is an unexpected, unusual, or extraordinary stress relative to the stress imposed on all other employees who are in the same line of duty and who have the same types of responsibilities. That's how we apply the reasonable person standard in every area of the law.
Counsel, aren't we ultimately getting to apples and oranges? Because the factual situation in this case, I got to tell you, in the years I've been a judge, I've not seen one where one of the officers had to make a tactical decision about, do I fire and risk killing my partner at the same time I got a shotgun in my face? I don't know that I've seen that more than once. So isn't that the issue, as opposed to, well, you both had guns, right? And you both could have, but you didn't, and so there it's with every case where there were guns involved.
Your Honor, if you look, I think the Sloss case answers that question, as did this court's cases, albeit unpublished, in Dunkelberger and Howe, where you look at not just that specific event and whether that exact situation, whether other employees were in that exact situation the same day. That is too narrow. The courts have looked at, for example, in the Sloss case, looked at whether as a first responder, and you see this also in Howe, we look at whether as a highway patrolman or whether as a first responder, the types of stresses and the types, including seeing people die, including seeing babies die, including being exposed to and participating in gunfights, that first responders, you do need to look, Your Honor, at whether those other deputies in the same line of work could have been exposed to the same stress. And the testimony here was that that Sergeant France, anyone could have been called out on that particular day. Anyone could have been the one who decided to go lethal based on the information that they had at the time, which you pointed out included the fact that this subject had a shotgun, was agitated, had just a couple of days before that threatened to kill officers. They knew going in that to expect that there was a pretty high possibility, if not probability, of violence or gunfire in this situation. And even the under sheriff and deputy, the chief deputy testified to that fact, that this is that having gunfire in this situation is something they should have expected. And as the video shows, based on the actions of the two deputies, they expected that there would be a pretty high chance of some gunfire. They had their guns drawn and ready. And this, as the courts have explained, you need to look at the overall duties. It's never whether another deputy on that same day was facing the exact same situation where they were looking down the barrel of a gun. It is a broader test.
The very witness you're talking about testifying to that also testified he'd never been in that position.
That's true, Your Honor, but...
So what we do is we line up all the people that have never been in that position and ask them if that's normal or extraordinary stress, but don't get anybody that's actually been in the position that would know whether it was normal or extraordinary stress, right?
With all due respect, Your Honor, that is never the way that the objective, hypothetical, reasonable person standard has ever been applied by this court or by the Supreme Court in that narrow of a way. You look at...
Let's back up a second. How do you get the objective, reasonable person standard out of the plain language of the statute?
That's how it's been applied, Your Honor, by the courts.
I know. I understand.
From Sloss and Barnes all the way through.
I'll avoid the temptation to talk about how many IC cases there are that don't,
yes,
and in my opinion, don't pay deference to the statutory language.
Right.
But I'm just wondering how one gets that concept out of the plain language. And I'd like to go back to something. Is the carrier contesting that the stress here was a substantial contributing cause?
No, Your Honor.
No, that's not. That's undisputed.
That has been stipulated.
The only
too.
issue is whether this is unexpected, unusual, extraordinary.
That's correct, Your Honor.
If this doesn't qualify, I understand this is purely hypothetical, but I'd like you to give me a situation in your best judgment that would qualify for a first responder. Something, and what would be an example, or one or two examples of an extraordinary event?
Your Honor, I think I have not thought about, hypothetically speaking, what would. I think that, for example, there have been situations, for example, in well, I'll tell you what would be.
Because no first responder has yet prevailed in this.
That's correct, Your Honor. Well, for this type. I mean, I would think that if, for example, there's a situation where a first responder is, there was a case, and I'm trying to remember which case it was that I was reading, but that he had, for example, for whatever reason, his wife or girlfriend with him. He was in his car, and he ended up having to respond, and there was gunfire. He was not expecting that, for example, at the time, but I would think too, if you have a situation where, where the first responder is perhaps just being called for to go assist in a school with, some kind of community or maybe safety, like a bike safety course or something like that, and all of a sudden one of the students pulls out a gun and starts shooting.
But officers don't receive training on how to deal with unexpected events. It just seems like this is such a line drawing exercise. I mean, to the nth degree that I mean, let's go. Okay, maybe let me ask this question. What we asked, your colleague, how aren't we obligated to construe the statute in light of the Constitution's language? And does that not, how would you interpret the statute in light of the Constitution? I have yet to see a case that actually cites the Constitution and talks about what a necessary risk or danger is in light of this statute. So help us out there.
Your Honor, actually, Findley, Toto, and LaPere all looked at both equal protection, and they looked at two of the three at Article 18, Section 8. And just as the arguments here are the same, although
they specifically focused on a necessary risk or danger?
No, they looked at whether treating a mental claims differently from other types of claims. Exactly.
Equal protection.
And that's all that's happening here, is that you're talking about the classification. Here you're looking at the statute specifically states that it has to be some unexpected, unusual, or extraordinary stress related to that employment. And so it subsumes in that the type of duties that are required by that particular line of employment. And so for purposes of, you are comparing apples and apples here when you are comparing the stressors that are faced as regular part of the duties of a Gila County deputy sheriff with other Gila County deputy sheriffs. And all of the testimony, every bit of it in this case, supported that. That is why they plan for the worst every day and hope for the best. That is why every single day that they are expecting that this could be the day that I have to pull out my gun and use it and kill somebody.
So hoping for the best and planning for the worst is how we avoid PTSD.
No, Your Honor, we're not saying that it didn't cause it, because that's only one part of the statutory test. The other part,
the PTSD arose from the circumstances that the appellant encountered that day on the job when he had a shotgun stuck in his
yes,
face.
Your Honor, that is stipulated too.
But that's not something you sit down and say, okay, shotgun in the face, yeah, that's pretty bad. But it's not really what we're looking for here. Machine gun from 30 feet. Yeah, that's getting there too. Do we have to do that? Do we have to break this down to the necessary elements that have to fit into a special classification?
No, Your Honor, and in fact, I think that's breaking it down too much. That is why the focus, the test, is what are the regular duties of a Gila County Sheriff Deputy and the responsibility of this particular claimant relative to all other deputies who serve in this position. The testimony that you do have to defer to, the ALJ's findings, so long as it's reasonably supported by the evidence, she faithfully applied the statute and the objective test that this court and the Supreme Court has articulated repeatedly, Your Honor, including as to first responders, in looking at the general duties of the other deputies or other law enforcement officers in the same position. The testimony was that every deputy in Gila County who goes to work every day knows that they could be called to any type of a situation, whether it be a domestic violence situation, which always has the potential for violence, whether it be a situation involving a welfare check, whether it be a suicide call or a robbery or a murder. Every single deputy who goes in knows that that could be the day that they have to use their weapon, and that is why they receive special training that all other officers, law enforcement officers, do in the state of Arizona. And so what you have to look at here is the testimony that was presented is that every single person who testified said, this is part of the job, this is why we train, because the duties themselves state that the risk of that you face the risk in the course of being a law enforcement officer, a risk of being shot, a risk of being killed in the course of duty. And so what you need to look at, Your Honor, is the fact that that has been uniformly applied, the objective standard in every single case, relative to the duties of that and responsibilities and expectations of that particular type of job. And that is all that's happening here. That is not, and the court has said specifically that differentiating mental, or this causation standard for mental cases from physical cases is constitutional under both provisions of the statute. And all this is an application of that to the particular duties and stress related to the employment. That's what the statute says. And and the objective, hypothetical, reasonable person working alongside claimant is the way that this court and the Supreme Court has always applied this statute and that statutory language. And if you, let's say you get rid of that and you just compare the stress faced by highway patrolman or a first responder to the barista working in a Starbucks. Well, that is going to run into equal protection problems because of the fact, and problems for the very same reasons that petitioner outlines here under Article 18, Section 8, because always the high stress first responder position, they are always going to be subjected to more stress, to more extraordinary stress, to more, whether you say unexpected stress and higher stress situations than the barista at the Starbucks. And so they will have an easier time actually meeting that threshold and that higher causation standard under the statute than people who work in non-stress or low-stress jobs. So it's not fair. It is appropriate, and that is why we apply a reasonable person standard that looks at others who are similarly situated throughout our law, not just here in workers' compensation, but in every area of the law. It's appropriate to compare like jobs and duties with the claimant's position. That's the way that we apply the reasonable person standard, and there's nothing unconstitutional or unfair about that.
Because we're doing that, then, because we're applying the reasonable or person or objective standard, then aren't we, as the appellate court, to look at the same exact facts and make our own independent determination of whether this was unusual, unexpected, or extraordinary?
No, Your Honor. In every case from Sloss to Barnes, Howe, Dunkelberger, in every single case, the court has held and determined and articulated that the fact that this is a legal standard does not mean that the ALJ's application of that standard is not entitled to deference if it is reasonably supported by the evidence. You do not look at this on a de novo basis. The only thing you look at de novo is whether the court applied the correct standard. Did she apply the correct legal standard under the statute? Did she apply the correct objective test as opposed to a subjective test? According to this court's current case law and the Supreme Court's current case law, she did. So then you look to...
What is the Supreme Court's current case law? Fireman's? Is that what other case law?
I think Fireman's Fund. Well, Sloss, because Sloss limits Fireman's Fund. So Sloss and Fireman's Fund both say that it is an objective standard and that it's required that the court is required to establish that it is unusual, unexpected, or extraordinary based on the particular duties and responsibilities of the job. That is how every case thus far has applied this standard, every single one.
Are you aware of any case where the IME doctor has actually recommend or actually found was extraordinary psychological stress, and yet the claim was denied?
Your Honor,
I mean, I just wondering if you're aware of any.
I'm not, except the case that, and let me just find it very quickly if I can. Barnes and Howe both looked at and discussed that it's not a medical determination.
I understand. Yeah, I understand that, but
Yeah.
I'm just wondering. I mean, it seems I think between the three of us, we've probably reviewed thousands, of, at least in the high hundreds of these types of cases, and very rarely have we seen an IME doctor recommend something and then it be denied.
Except that this IME doctor specifically said, I understand that's the medical causation. And that medical causation was stipulated to here. That's what the party stipulated to. In other words, that's why there is no question that it caused it. But that meets the substantial contributing cause.
The problem is that many of the cases that you're referring to are gradual cases. They don't involve a single precipitating traumatic event. Those are very few. The truck driver, that's one, the truck driver who
Correct.
Your opposing counsel referred to, that's one that's a precipitating event. There's not that many.
This
Those
court,
types, as opposed to the gradual, like Howe, I was on that panel.
Howe,
That
correct.
was not a single precipitating event.
except for the Dunkelberger case actually was, and Dunkelberger actually distinguished and talked about that there's a different quality of case that deals with the gradual stress, and talked specifically about like Fireman's Fund and Barnes. But there was a single precipitating event by the computer forensic analyst who saw a particularly disturbing set of child pornography photos on that day that all agreed, including the medical testimony, precipitated that specific stress-related injury. And so, yes, that has been applied here, and the court, and I believe Judge Thompson was on that panel, and it specifically talks about and distinguishes, then you have the gradual stress injuries. So, yes, Dunkelberger applies that exact same test here, and looked at the 6 other employees who have the same types of duties. Were they the exact same photos, the exact same especially disturbing photos that particular detective looked at on that day? No. The court looked at the general duties of those 6 individuals who engage in that type of work and said that the stress that this man was subjected to as in the course of his employment was no greater stress and no different than that the other 6 people that are performing the same duties are subjected to every day, and therefore it was not compensable.
Thank you, counsel.
Respondent's argument is all focused on risk. The case law and what we're dealing with here today is an event. Events don't equal risk. Risk don't equal events. The statute says unusual, unexpected, or extraordinary. It's disjunctive. It has to meet any one of those requirements. None of the case law focuses on tactical training. They all focus on actual events.
Well, talk to us about a little bit more about the objective person standard.
Sure.
How does that play in? I mean, what's wrong with counsel's argument that we have to look at in every situation, whether you're working at a Starbucks, a Circle K, or whether you're working as a first responder, we evaluate it based upon what an objective person with those duties what kind of stress what a reasonable person would feel in that situation.
Sure, Your Honor. To your point, if we focus on the event, if we focus on all those witnesses that were paraded in front of the ALJ, the defense witnesses and the witnesses that we brought in front of the ALJ, the hypothetical objective reasonable person standard, none of those witnesses had ever been in a gunfight. None of those witnesses had ever taken a life from point blank range. So you can use the hypothetical objective reasonable standard here, and if you focus on all the facts, it all lines up to the petitioner's argument.
But how do you get there from here? all those people talking about what's reasonable in that situation have never been in that situation.
Exactly. So, to your point, Justice, they were led, essentially, in the hearing, and essentially, they said what the statute says. In other words, they lined it up just so it met the statutory requirements. That was their argument, okay? But none of them have ever been in that experience. None of them have ever had to take a life from point-blank range.
So they're looking at something and they're applying a standard. They're appraising what the impact should be of that.
Right, exactly.
Never having had to address the impact.
Exactly. Never having to be in that actual experience in 135 years of law.
Were they brought in as expert witnesses, or were these just lay witnesses?
Lay witnesses, Your
So
Honor.
the lay witnesses are testifying to something they have no experience in.
Exactly.
Thank you.
Exactly. If this is so usual, why is there not training for it? Why is there not training for the after effects of taking somebody's life at point-blank range? There's not. There's nothing in the testimony, and there's nothing in the brief. It's clearly unusual. It's clearly extraordinary. It's a disjunctive statute. The cases that she mentioned, Finley, Toto, and Lepar. Toto and Lepar focused on the substantial contributing cause and whether that's constitutional. That's not what at issue here. Finley simply stated that mental claims all need to be treated the same way. So there was no carve out for people with high stress jobs to have a higher standard. Finley just said that all stress claims need to be treated the same. Again, I'm going to say what I said earlier. The entire argument is misfocus. This is a compensable claim. This is clearly unusual, unexpected, or extraordinary, and should be found compensable. None of those witnesses that testified today had ever been in that circumstance. So they can't attest to the fact on whether it's unusual, extraordinary, or unexpected, because they've never been in a gunfight, let alone from point-blank range. We respectfully request that the ALJ's decision be set aside. Thank you.
Counsel, thank you both for your arguments this morning, which have been very helpful. The court will take this matter under advisement and issue a decision in due course. Thank you.